In the polished offices of a London lending firm, Leslie Ltd, the business of money never slowed. Neatly dressed clerks shuffled papers, answered phones, and reviewed credit requests, all to ensure one thing: that loans went only to those who could be held accountable. Until one day, in walked a confident young man, crisp in appearance and clever with words. He introduced himself simply as Mr. Sheill and claimed to be 21 years old. He spoke eloquently, wrote well, and provided references. What he did not provide, however, was the truth. In reality, he was a minor, under the legal age of majority at the time. But he looked the part, and more importantly, he sounded it. Trusting his word and the air of responsibility he exuded, Leslie Ltd granted him a substantial cash loan. There was no concern at first. The papers were signed, the money was disbursed, and the agreement was filed away as just another deal. But time passed, deadlines were missed, letters were returned unanswered. The firm grew suspicious. Eventually, they uncovered the truth. The well-spoken Mr. Sheill was, in fact, underage when he took the loan. The firm was stunned, not just by the deceit, but by the legal implications. Under English law, minors are generally not bound by contracts, except in cases involving necessaries, like food, clothing, or education, or contracts clearly for their benefit. Lending money, the court had long said, was not a necessary. That meant the loan contract was unenforceable. But Leslie Ltd wasn't ready to walk away. If they couldn't sue him in contract, they'd sue him in tort. They filed a claim for deceit, the tort of fraudulent misrepresentation, arguing that Sheill's lie had induced the loan and caused their financial loss. A person who lies, they said, should not be allowed to keep the fruits of that lie, age aside. Their logic was compelling, but the law was not on their side. When the case reached the Court of Appeal, the judges faced a difficult tension. On one hand, Sheill had clearly lied, deliberately, fraudulently, and to his own gain. On the other hand, the law had always placed a protective shield around minors, shielding them from the consequences of contracts entered while underage. That shield, the court reasoned, could not be pierced indirectly through tort. If the courts allowed an action in deceit for a contract that was void due to infancy, they would be undermining the entire legal protection the law gives to minors. As Lord Buckley put it, you cannot do indirectly what the law forbids directly. If the minor could not be sued in contract, he could not be sued in tort when the tort flowed directly from the same transaction. To do so would, in substance, make him liable for the contract through the back door. Leslie Ltd pleaded for fairness. They asked for restitution, for the return of the money or its value. But the court again refused. Since the money had already been spent, there was nothing left to return. And the law would not force a child or anyone acting under legal incapacity to repay money that no longer existed. And so the court dismissed the case. The judges did not celebrate Sheill's conduct. They did not excuse it, but they insisted that the law must protect the principle of legal incapacity even when it seems to shield wrongdoing. The danger of the alternative they feared was far greater, that minors would be left exposed to manipulation, debt, and exploitation, simply because they once lied or looked older than they were. And so, Leslie Ltd versus Sheill became a defining case, a cautionary tale for lenders, a lesson in legal doctrine for students, and a thorny dilemma in the conscience of the law. It reminds us that sometimes the law must choose between justice and protection, and when it does, it often chooses protection, especially for the vulnerable. For today, in every common law classroom, the name Sheill still echoes as a symbol of how truth and liability do not always walk hand in hand, and how even a lie in the hands of a child may find refuge in the law's embrace.